Morning all. For anyone I haven't met, my name's Mike Guerin, and my job this morning is to be your MC at a conversation about the Great Artesian Basin. We have a mixture of people in the room here and people online, so for whoever's speaking, we need to be in the chair or standing beside it, and questions from online will come through the chat as well as within the room. So we'll just do our best to keep everybody as involved in the conversation as we can. Can I acknowledge Colin Boyce, Member of Parliament, huge supporter of AgForce and powerful supporter of the GAB campaign. Colin, thank you for being with us again today, and Colin will say a few words shortly. To our legal team, who I'll introduce shortly, including our King's Counsel, who's kindly agreed to spend some time with us this morning talking through the last few months. To Georgie Somerset, our General President, Shane McCarthy, our Deputy, and most importantly to all of our members who are in the room, who enable us to do what we do. Good morning and welcome to you. The order of proceedings, I've asked Colin to say a few words. After that, Georgie will talk a little bit about the organisation and the broader campaign, and then we hand to legal counsel, Shane Roberts, our solicitor, and Donovan Horton, our King's Counsel, to talk through things from the legal perspective, and they have time for questions and whatever conversation we want to have to get a better understanding of what's gone on in the last few months. So without further ado, firstly, Colin, to you. Welcome to the chair.
Hi, thank you.
Well, thank you, everybody, and hello to whoever's out there in computer land, I suppose. So this is, the start or the finish of a very, very long, protracted campaign for me, particularly in respect to this whole carbon sequestering idea brought forward by Glencore and started many years ago. And it's actually what actually drove me to politics in the first place, all the way back in 2015, 2016, when they had a very similar proposal at Wandoan in central Queensland, right adjacent to their what was the old MIM Extrata coal lease at Wandoan, and where they intended to do a similar project. We put a stop to that in 2018, 2019. I spoke about it in my maiden speech in State Parliament, and of course they shelved that program and then have moved forward with a similar same sort of thing at Mooney, and it's come to a finish now, come to a close, we think. The Queensland government has obviously legislated against carbon sequestering into the Great Artesian Basin. What worries me mostly is that this is only a piece of legislation that can be changed at some point in time in the future by any flavour of government that wishes to do so. So I would like to see this whole issue go much further than what it is, and that is to put some amendments into the Federal EPBC Act, and we tried to do that late last year in Federal Parliament by moving some amendments to enable the water trigger of the Federal EPBC Act in respect to onshore carbon sequestration. Those amendments failed. Both the Greens and the government rejected them, but you can see the record of that on Hansard in respect to what happened. Both the government and the Greens are nothing more than hypocrites when it comes to all of these emissions targets and so forth, particularly when you start understanding what the EPBC Act actually says and reads and what it means in respect to the Great Artesian Basin. There are no protections around the waters of the Great Artesian Basin, and that needs to change. And that is what we're lobbying hard to do. And I would like to see both New South Wales, South Australia and the Northern Territory follow suit in respect to legislating against putting hypercritical CO2 fluid into the waters of the Great Artesian Basin. The basin, as you all know, is the world's largest underground potable water source. It is unique. There is not another like it on the planet. And in Australia, where we are possibly the driest habitable continent, why on earth would you even contemplate, compromising this most precious water source? The other thing I think everybody needs to bear in mind that the principle behind this whole project is not particularly about sequestering carbon dioxide per se. If you have a look at the tonnages and so forth, whilst they're huge, in the big scheme of things, they're absolutely meaningless and nothing. What it's about is generating billions of dollars worth of carbon offsets for a variety of companies under the federal government's safeguard mechanism, where 215 of Australia's biggest companies have to lower their emissions targets by 4.9% to meet their 43% target by 2030. All of them have identified the same issue, that there's just simply not enough carbon offsets available. And if you start doing the numbers on the tonnages, the cost of doing so, the cost of carbon offsets, all according to Glencore's EIS statement, use their figures, you end up with a figure that's somewhere in the vicinity of hundreds of billions of dollars. And that is what this project is all about. It's about generating money for a large multinational company based in Switzerland, who is in partnership with a Chinese energy company, Hanang, which is part owner of obviously the compressor station and Millmerran Power Station, which is the source of this particular project. For me, it'll be interesting to see where we finish up in the coming months and so forth. It'll be interesting to see where Tanya Plibersek, the Environment Minister, Federal Environment Minister, goes with this. I and along with my colleagues are lobbying hard to have her change the EPBC Act, or at least amend it. We've had the Senate inquiry, obviously, which has made those recommendations. I know they will be spoken in the Senate at the next sitting, which is in a week's time or thereabouts, 10 days. Whether that comes to the lower house to be debated is speculation. I imagine once it's been through the Senate, it will come to the lower house and be tabled in business, and there it will sit. My take on it is that the government doesn't want to approach this subject because they don't want to upset their emissions targets and bring more scrutiny to the fact that many of these targets and their goals are simply unachievable. So I'll leave it at that. Been a long, hard battle for me. I'm still there punching away in the background, and I will continue to do so.
Thank you, Colin. Your support to AgForce's work and more broadly for the basin enormously appreciated and is ongoing. So thank you, Colin. Our second speaker needs no introduction, I don't think. AgForce's General President, Georgie Somerset. Georgie, over to you.
Thanks, Mike, and thanks, Colin, for those words and that intro. And thank you to members who are online and staff that are online, as well as those that are in the room, and to the legal team for being here today. Really appreciate the support and the interest in what is happening with all of this. I'll just pass you your phone, Mike. AgForce is a great believer in the strength of advocacy, and we were talking about this morning and said that it's both a science and an art, and it's very inexact in how it's prosecuted because it's a constant moving platform. But our modus operandi at AgForce over the last 25 years has been about building relationships, having conversations, and people have often heard me talk about being in the room, and the aim being to actually change what might be coming into legislation or decision making before we end up with the perverse outcomes. It is so much more difficult to change something once it's out in the public space, and many people have been on the back of a ute with me, trying to protest once the legislation has come in. So we're a great believer in trying to be part of improving things before they become legislation or policy or regulation. But when the time comes to actually stand up for members, the strength of a member-based organisation is that because we represent members, we come back to the core of what's important to agriculture and to producers right across Queensland. And that's the strength that we can stand on. So, what's really interesting about this process is that really in under 12 months, we've achieved some significant outcomes in terms of the change in Queensland legislation, the work around bringing to light what's happened, the Senate inquiry. It's been quite quick, and it's in advocacy terms, it's actually moved very quickly. But this is part of a larger conversation. Just as Colin was saying, it is a larger conversation about agriculture being constantly put under the pump around other people's targets and other industries' targets. And the strength that I believe AgForce has is that we represent members. And so we reflect what is important to members. Members bring those issues to us, and then we all galvanise around them. The only reason we've been able to stay so strong over the last 9 or 10 months since we first wrote that letter to the Minister seeking a review of the decision of February 2022 was that we know that we stand on behalf of members. And you cannot deny what is at a member's interest. And it is about standing strong for agriculture. It's about standing strong for food security and for the environment right across Queensland. So the strength that I believe your organisation has is that we are here as your voice. We are here to represent you, and we are that leading voice of producers from right across Queensland. This battle for the last 8 or 9 months is critical because it is about standing up for agriculture and the environment in the light of targets that have been created at a national and a global level that will have perverse outcomes for food security into the future. And they'll have perverse outcomes for the environment because they're being decided in isolation from agriculture. And when you leave agriculture out of the conversation in the early stages, you leave it out at your peril, because we will literally, shut the gate. We will stand up for ourselves, and we will stand united. And I think the strength of this campaign has been reflected in the fact that people are prepared to stand together to fight for what's important for them. So I'm really looking forward to the legal team stepping you through the process that we've been through. But I want to thank all the members. There have been so many members of the public, people right across urban Australia as well, who've stood strong with us to protect the Great Artesian Basin. We've achieved a lot in 9 or 10 months. We've still got a bit to go. We need to protect the Great Artesian Basin right across Australia. We've achieved a lot for Queensland, but we are not done yet, and we do need that protection in the EPBC Act federally, and we will continue to advocate for that and have bipartisan support going into the federal election. It is critically important that we stay strong and we stand together and we continue the work. But thank you to everyone for your support. It has been enormous, and thank you to the legal team for your unwavering digging into finding the information and revealing the disingenuous nature and the absolute ignoring and leaving agriculture out of the equation. So again, just thank you for your support, and I look forward to the update from the team. Thank you.
Thank you, Georgie. I want to spend a couple of minutes introducing each of the legal team to you, because they've been a fantastic foundation for the campaign over the last 8 or 9 months. First of those is Shane Roberts, who you'll hear from next. And this started when a member of AgForce, who's very close to where they're proposing to pump industrial waste underground, were working with Shane Roberts and others to think about their rights in resisting a global mining giant putting waste underground. And that member came to us and recommended the legal team that we started with, including Shane, who's going to speak next. Shane and the rest of them have been fantastic in my experience. They've been unwavering, as Georgie talked about. They've been available 24 hours a day, 7 days a week. When times have got tough, things have been needed to happen quickly. They have happened quickly. And I think it's in no small part to the legal team we put around us. So to introduce the first one, Shane Roberts from Holman's behind us. Shane, welcome to the stage, and thank you.
Thank you, Mike. Look, I'll keep it fairly brief because the main show, our KC, speaks after me, so I'll just give you a very quick wrap up. I first got involved in this matter when Ken Cameron, who a lot of people will know, came to me with a friend of Ken's and another barrister, Matthew Donovan, and we put all the planning together at the very beginning. I must say that I was shocked when I first saw what had happened, particularly at federal level. I was shocked that the federal government had essentially ticked off the project to put what we refer to as industrial waste into such a pristine water source. Queensland's got 60% of the Great Artesian Basin, and what we saw was the potential for that, which is the sole water source for over 2,200 AgForce member properties, to put that at risk. Interestingly, what you'll see is later on when the Queensland Department, DESI, had a look at this particular proposal and actually dug into it with some of the science and the scientists. And you look at on the DESI website now, there was a release issued on the 28th of May of this year, talking about the fact that this aquifer that was supposedly just going to sit there in perpetuity and hold all of this carbon and industrial waste was found to be, when their scientists actually had a proper look, it wasn't a confined aquifer, which meant that it flowed into who knows where and how far it flowed. And people talking about, oh no, don't worry, if there's a problem with the science, we'll just get in there and take the stuff out. How do you do that? How do you do that underground when it's not confined? And again, why weren't people listening? I just wrote down before what Georgie said, ignoring agriculture. And that was one of the main things that we saw at the very beginning through all the decision-making process. Somebody was listening to the dollars and not to the actual farmers out there, which is scary for the rest of Australians, because what happens with food security when these sorts of decisions can be made? We went through the court process, and can I tell you now that that AgForce will be seen and is being seen in a completely different light, seeing that at the end of the day, it was the only person, only party, only organisation that would actually stand up, put its money where its mouth was, and get into court and get in front of a judge. And for those of you that were up there on the 11th of April when we had the first the first hearing, I have never seen a courtroom so full as I had that day. And in fact, Mike and I had gone up to the court and some of the other AgForce people a few days beforehand to talk to security, etc. And the court actually moved us into the biggest court, knowing what a turnout we'd get. And there's some famous photos, out the front afterwards with everybody holding up their banners. It was amazing. And, the kids were there, everybody was there participating. And the thing I think that did is it sent the message that not only is AgForce prepared to go to court, but AgForce is also a powerful organisation with much support. And that came across. And I don't think it's any coincidence that shortly after that, we saw these sweeping changes at the state level. So now we probably have the most protection that we've ever had at the state level for the Great Artesian Basin. But as all the previous speakers and particularly Colin have said this morning, that we can't let it stop there, because anybody could get in and change that legislation with the stroke of a pen in Parliament at some stage. What we need is the federal government to take the Great Artesian Basin seriously and to actually give some weight to the agricultural industry. We want to see the whole of the Great Artesian Basin in the other states and the Northern Territory protected, because what happens if there's a development over the border in South Australia? What's to stop that development then pouring through into the Queensland side, no matter what Queensland laws? This is why it's a federal issue that needs to be pursued. So whilst we've won the battle for the present, we need to then focus on what's the task that's ahead. And it's still a big task, because we need to get federally protections so that not only the Great Artesian Basin, but water generally for agriculture is protected, so that we don't have to have this sort of situation again. And we don't have to then all be banding together and going to court. But having said that, the fact that you've done it this time is a lesson for everybody out there and all the other interest groups. And so AgForce is a major player in that conversation now, because of the fact that it actually put its money where its mouth was and went to court. So thank you very much. Particularly special mention to Georgie and Mike, have been unwavering in their support. And Mike's right, as the pressures come on, because we had a very short timetable to get to trial because the court realised how important this issue was. So we were, on the phone, many weekends putting all the documents together. And also thank you to our barristers that are here today, Jonathan Horton, who will speak in a second, and Matthew Donovan. And we haven't got Joshua here as well, but we had a fantastic stable of barristers, and they made sure that we met that very tight time frame. I haven't had a matter in the federal court where from the first date to that trial sitting down was only a couple of months in such a big matter. So we had a really tight time frame. Everybody did what their duty, and the barristers in particular were amazing in being available and accessible and turning the paperwork around very quickly. So we met all the timetable on the way through. And it's that momentum that you can get in litigation that actually wins you the case. And so in no small way, can I say that we owe a big vote of thanks to the barristers that we had involved in this matter as well, who were able to turn things around so quickly so that we got to the stage where today we've got that partial protection and tomorrow hopefully the federal protection. But thank you very much. And John.
Thank you, Shane. I'll make two introductions. Firstly, to a gentleman who's not going to speak formally unless you have any questions for him, but to Matt Donovan, one of the barristers. He's been with us since the start, and I can only echo Shane's comments. Always available, always helpful, very enthusiastic about the subject, dug deeper than I've ever seen a barrister dig, and been a huge help. So Matt, just from us and from industry, a huge thank you to you. Just want to introduce our King's Counsel, Jonathan Horton. Early on in this campaign, our legal team set about thinking about who could best represent us given what was on the line. And what we got back was that Jonathan Horton was the King's Counsel that could best look after us, was an expert in matters around judicial reviews, etc. And I had met Jonathan before, and I'm not a lawyer, but Jonathan's been an enormous help. Very available, incredibly detailed, I guess as King's Counsels are across the law in a way that I've never seen before. I've never dealt with a King's Counsel before, but Jonathan, your support and help to industry has been enormously appreciated. So a huge thank you from us, and we welcome some time having a chat to you this morning from your perspective, and also we may have some questions online and from the room after you spoke. But Jonathan, welcome and thank you.
Well, thanks very much, Mike. This, as you know, was they're difficult matters, these public law matters. They're dynamic and they're fast moving in a way. The decision was made years ago, but the reasons were only given recently. And so we had to move quickly, I guess, to the court. You've only got 28 days from that stage to commence. It was, we had to frame your case, and then, of course, we had to go to court and try to get a hearing date in the near future. And it was a big support, I thought, and a very big decisive factor in the judge ordering such a fairly quick hearing. I know it doesn't seem quick, but we would have been on today. But with all the preparation, it is quick. But the fact that so many elected representatives turned up, so many people from AgForce, and of course, so many members, that factor for me was very important in the judge realising it was an important case, public interest case. In getting the hearing date, very important because it provides everyone with knowledge that regardless of what happens, this thing's going to be determined. People can't put on the back burner. People have to give it attention. It helped getting a hearing date. It helped getting attention from the other side, getting priority. But it did one other thing, and I know this through other means, really, that I think it also helped in the Queensland government's decision about legislating. Because as you know, in the public sphere, there's so much happening. It's a matter of getting the focus and the attention for your issue as being the most important. Well, it certainly did that, because I know happening in the background was that provoked a lot of attention then about the legislation. Even if we'd won the litigation today and tomorrow, it would have gone back to the federal minister for redetermination according to law. This is the funny thing in public law. It goes back for redecision by the public servants, in effect, or by the minister. So the win that you got by legislation is way better, because it doesn't just go back for redetermination. It's what was Paul Keating's old term, LAW law. But now, of course, it can be changed, but it's hard to change. So it's a very, very good win to have that. And really, I think that you should congratulate yourselves in a way for putting the effort in to give it your priority to turn up in court, to get the hearing date, and really secure it in the public agenda, I think, for that 3 months, which is the time it took to get the legislation through. As you know, along the way, the litigation was originally just against the federal minister, because the federal minister was the decision maker or delegate. CTSCO joined in the litigation, so we had, this dynamic, this change in the litigation along the way. Both of them went very much full on in two ways. One, resisting the case, saying the case was no good, but also saying, surprised me, I didn't think it would happen, but that AgForce wasn't the right body to represent people in the Great Artesian Basin. And that did surprise me. I haven't seen that happen for a long time. Certainly it doesn't happen with environmental groups. Environmental groups are regarded as having standing in these matters, representing people who have interests. And it was frankly a disappointment to me to see that the company and the minister would even suggest that. I think it was not I think it wasn't a right thing to suggest. And we've made a very good defence of why AgForce did have standing. I was looking forward to that argument, but in the end, the other side rolled over on the question of insisting on their costs, so there was no occasion to run it. And judges don't like hearing because they're busy. Judges don't like hearing, historical matters or matters of academic interest only. So, look, really, it was wanting to say thanks for your support. There's nothing worse than running a case and having no client behind you, because you think I'm invested in it, I'm ready for the fight, but the judge thinks, what real people are interested? It's one thing to have lawyers interested, but where's the real life in it? And in this case, having everyone there at the outset meant it put it squarely in the judge's mind that this was important. That's why we got the hearing date. I think it's a great contributor to why you got the legislative solution, and just showed overwhelming support for it. But really, I just want to say thanks for your support. Thanks for the brief. It was very interesting. It's a sort of thing I do and the sort of thing I like doing. There's not many ways, I mean, there's politics, of course, but apart from politics, there's not many ways that you can bring to bear real power against powerful interests like government. And one of the reasons I enjoy law is it's, power only understands power, I think. It doesn't understand niceness. It doesn't understand pleas of mercy. It only understands its own language. And law's this great way, when it works, of answering power with power. There's nothing like bringing down a wrong government decision with a decision of a court. It gives me enormous satisfaction. If it's wrong, because law's the only thing that will ever speak to that political power, which otherwise, of course, we're all powerless against in a way, unless we get in the political sphere and influence it. But for me, this is why I'm in law, and it's a sort of rewarding thing, if you like, to act on behalf of real people wanting a good solution and hopefully be able to deliver it, even if someone else delivers in the end. But that doesn't matter. But thanks for all your support in the litigation, and good on you for taking the step to, which is always difficult and costly, and it has risks. So I really wanted to say that, and I'm happy to take any questions if you think I might be useful at answering.
Thank you. Well, so firstly, in the room, are there any questions for Jonathan while we have him? Colin, could you come up here? Sorry, we'll just keep everybody online as well. Stand on the square and ask the question. Thank you, Colin.
Thank you. Well done. Appreciate all of your efforts. So my question to you from a legal point of view, if the world was perfect legally, how should the legislation be drafted in respect to changing the EPBC Act to put significant protocols and protections around the Great Artesian Basin, in your opinion, from a legal point of view, knowing that you've delved right into this thing and knowing what the original decision was made by a fellow called Andrew McNee, and he is a senior bureaucrat. He's not even the minister or anything to do with it. And if you look into the specifications which were put forward to Glencore in their original submission, they didn't even mention the Great Artesian Basin.
No, well, the Queensland legislation does it quite well, because it not only says that this tenement that allowed the injection doesn't allow it, but it also says that all land in the Great Artesian Basin is unavailable land for the purpose of a carbon injection. So that's a really good way of doing it. It just declares, in a way, as a legislative fact, as a conclusion, that environmentally speaking, the Great Artesian Basin is something that shouldn't be subject ever to this sort of activity. So that I thought was a neat solution to say it's just unavailable. It's unavailable because it's against the policy of the environmental protection the Act prescribes. So it's not a bad way of doing it. It says, well, otherwise it's up for decision, but in the Great Artesian Basin, there shouldn't be a debate. I thought it was a neat solution and seems to be a legally effective one.
Thank you. Bill.
Which one?
Oh, the black one. That's a good question.
Bill Gay.
G'day.
I come from 4 hours west of Townsville.
Yes.
I've been the Great Artesian Basin member of the advisory board for 19 years, 20 years. Now, my question to you is, first off, are you aware of the amount of money the state and federal government and landholders have spent recovering water pressure in the Great Artesian Basin?
Yes, I am a little bit.
Yeah, 350 million or more. And it's done a hell of a good job. In as much we've got up to 15 to 20 metres recovery of pressure
Yes.
over most of the GAB. But the other thing, as far as I'm concerned, is why the hell I was on the GAB advisory committee about 9 years ago. We were asked to put an opinion across to them, to Glencore, whether we should allow carbon sequestration there. We flatly refused it then, and it's come up again.
Yes. Yes, it seems to me, and I run a lot of cases in this field for miners and landholders and governments. Seems to me what's happened is it's the quid pro quo. It's the trade-off for allowing the mining to do the emissions. Is this hope, if you like, of these abatement programs, and this, of course, being one of them, as was said earlier, that this is the real pressure for it is to say the only way we can allow it is if we allow for some novel technology, if you like, some trial technology which has the hope of giving this abatement, even if it doesn't ultimately. But this is the pressure that's happening, I think. But the pressure is changing a little bit, I notice, in those cases, because governments in environmental authorities and so forth are insisting on more sophisticated conditions, saying you'll explore all available technology, but without insisting on one. And without being too prescriptive about it, which I think is a better way forward, because companies might not have the same pressure to pursue these sorts of things, but might look at other things, electric vehicles and so forth is the other way I think people are doing it.
It was talked about pressure, the immense pressure they're going to have to force the stuff down the hole.
Yes.
And my worry is also, have they been doing tests that we don't know about up there?
Yes.
Thank you.
Thank you. All the best.
Thank you, Bill.
Just yet.
The black square.
That's Mike.
That's right.
I'm Sue Webster from Australian Country Choice, a large beef producer. This isn't actually a question for Jonathan, but it's more for the room. Looking through the submissions to the Senate inquiry, I was quite surprised by the number of environmental, alternative, green, Indigenous, organic groups that were all putting their pen to paper in support of this action. And I'm wondering, was there a trigger? Do we know what brought those adversaries to conventional agriculture onto our side? Joe Colin.
Yeah,
John Colin. Okay.
I can briefly answer that. And there's an old adage in politics: success has many fathers, and failure is an orphan. And without trying to claim credit, because AgForce and a whole range of people have done a wonderful job pursuing this whole issue. But I did, through my office, spend a lot of time lobbying various groups of people, including various Indigenous corporations, length and breadth of Australia, our local government councils and so forth. As many people as we could think of, we asked them to write submissions, and of course many of them did. One of the most interesting submissions well, there were two submissions in that Senate inquiry that pricked my ears. One of them was the Environmental Defender's Office, who's been absolutely silent on this whole issue right the way through until I wrote my submission. And the last paragraph of my submission was that the Environmental Defender's Office be brought to task through Senate estimates to ask them why they had been silent on this issue. And then all of a sudden, they put in a late submission so that they could tick the box. And the other interesting submission which I think everybody should read, is the one from Andrew McNee, who was the senior bureaucrat who originally signed off on the deal. And it explains in detail what the process was in respect to him doing his job. And he was only doing his job. And what this does is highlight the fact that the EPBC Act puts absolutely no protections around the Great Artesian Basin whatsoever.
I might just add to the question, Jonathan, you might have some thoughts as well, but in an advocacy sense, Sue, one of the things that AgForce, and I think us in industry are learning over time, is the more we work together, the more chance we've got of fundamental reform. And these things are becoming, they've always been important, but more and more critical and closer to us. So I have a view that people are realising that we all care for the same thing. So rather than standing in corners where matters, where we have common interests, if we stand together, it's a much more powerful outcome. And I was telling Georgie last night, I'm currently talking to a group who are not normally naturally on AgForce's side on these matters, so are very keen to work with us on the next piece of the EPBC Act review. And in their words, they're coming to the realisation that where we have common interests and we stand together, we'll have a much better set of outcomes where industry, community and environment can all grow and strengthen together. So that's my view. We're a bit disappointed some were late to the party. We're a bit disappointed some groups didn't join at all. But we hope one of the lessons for this is if we join together and work together, put all our resources together on a common issue, we've got a much better chance of the right outcome. So that's my view, or AgForce's view, Sue, for what it's worth. And hopefully a great lesson when you all take out of this, as well as the other benefits. But Jonathan, I don't know if you've seen this from a legal perspective in that question.
Yeah, well, like I think there's that power, obviously, in being together on these issues, and then using the litigation where, not always, but where appropriate, judiciously, the litigation can add the pressure, if you like, or the time imperative and the fear, if you like, if it's a good case. But used judiciously, the legal system combined with this can often be very, very effective.
Yes. And Jonathan, I could just touch on that for a moment. It appeared to me in the last 48 hours before we agreed to vacate court that fear was an element in the opposition. Jonathan, is that a fair comment?
Look, I think it is. I think the pressure always, the deadline, you're going, it's one thing to persuade yourself in your own office or your own chambers or at home, but saying something out loud to a judge in 2 days when you're preparing it focuses the mind. So again, it's that D-Day, if you like, that you can't avoid. The hearing's not going to be adjourned or postponed. You're just going ahead, come hell or high water. But it's a great line in the sand where you have to publicly explain yourself. So again, used in the right way with the time, it's pretty powerful.
Yes. And one of the things I heard, which I think was helpful, was when the court decided to live stream this.
Yes.
So that's very unusual for a federal court, I understand.
Very unusual. It comes again from that first hearing where the judge saw with their own eyes that there'd be 300 people there.
Yes.
And the public importance of it. So it's very, very rare to have a hearing live streamed.
Yes.
But again, obvious recognition of the public interest in it.
Yes. And in my non-legal terms, the Australian government was about to stand in court and defend investing in coal mining and pumping industrial waste into water resource a few months out from elections. So that brings me back to this thing about fear. All of a sudden, every Australian could watch it and we could record it so that for anyone who didn't watch it, we could replay it. That's the element of fear and the art of advocacy.
Yes, and we were the applicants because we got to speak first. So it's a nice thing to be able to stand up and explain on live stream what's going on. So it's a good forum when it's right.
Yes. Thank you, Donovan. Any other questions in the room? Yes. Please come forward. And I'll just ask you to stand here just so that everybody's an equal in the meeting. Thank you.
Thanks, mate. Thank you. Judy Mewing, we've got a property in the Brisbane Valley. Just maybe out of ignorance, but simple question. Have the Greens made a submission in regard to this?
No, it was only the Minister and CTSCO who could make submissions here, but they didn't seek to be joined. They could have, I suppose, asked to be joined, but no.
Has there been any interest from local Greens or
not that
federal Greens?
No, not that I know of in the case, that's right.
Which defeats the purpose of being Green, isn't it?
Well, that's right. I suppose they can partly be joined, like AgForce could and would have similar sorts of sound. But no, I suppose you're right. It was a bit surprising.
Is that something to pursue?
Well, it's another way. yes, it's something in the future we might suggest to people, because again, they would have standing, like AgForce has standing. Yeah, but that's another, I hadn't thought of that, but yes, okay, thanks.
Thanks a lot.
We got any questions online, Tanya?
Oh, Colin,
Yes.
we do have one.
All right, we'll go to the online after Colin. Colin, come up. Black square, please. Black square.
I'm taking up all the time. I would just like to add a couple of comments in respect to that last question in regard to the Greens. So I'll go through a series of events. Last year in federal parliament, there was a bill before the Senate, which was called the Nature Repair Bill. And it had been through the lower house and went to the Senate, and the Greens moved a suspension of standing orders in respect to that bill to include shale oil and shale gas in the EPBC Act. And because they did that, that gave us the opportunity to move the amendments that I spoke of in respect to onshore carbon sequestration, which when it came back to the lower house. So when that actually happened, the Greens voted against it, along with the government, and mostly because they didn't understand it. No, if you go back through the Hansard records and listen to Adam Bant's speech on the matter when he spoke on it in the lower house, it's just appalling. So having said that, when they suddenly realised through a lot of lobbying through me and other colleagues outside Parliament that I deal with in respect to the Green movement, they then all of a sudden realised that they got on the wrong side of the political fence. When the Senate inquiry motion was moved by Senator Hanson, the Greens were then very supportive, which was a complete 180-degree backflip on their former stance on the whole issue. So I would suggest in what I see down there of the Greens, they are hypocrites. They do not do the work. They do not even understand what they're doing half the time. They've turned into a party that is more politically pointed and interested in scoring political points rather than achieving outcomes.
Are you happy to read it out?
Sure.
Yep.
We've got two questions. So the first one is, could you give us a sense of the relationship and communications between Glencore and the Australian government that has been uncovered by the exchange of information ahead of the planned court hearing?
Yes, well, first of all, they had aligned interests. They both said that AgForce didn't have standing, which again was surprising. We wrote to the Commonwealth Minister and said, in light of Glencore being in the litigation, the Minister should take a back seat, which is the normal course, which is what should happen. If the matter was remitted back to the Minister should take a lesser role in the litigation, because otherwise might give an impression of being partial to any re-decision to be made. The Minister really didn't accept that. The Minister said that they wouldn't agree to take the back seat until they decided. That's unusual and inadvisable, in my opinion. Decision makers, if there's some active protagonist in the litigation, should take a back seat saying, well, we remain impartial because we won't have to redecide. So that was the first thing that was a bit surprising. Second, they were sort of aligned. I'm not suggesting they copied each other. That didn't happen. But you know, they both lined up against us and both lined up against us in a material way. It's not a colluding sort of idea. They didn't sort of rely on each other's submissions. They did each other's cases independently, but they were supportive of each other. They were supportive of each other fully, I suppose is the way to put it.
Okay, the next question is it inevitable that Glencore will attempt to drill in other states, and what would be the precedent that AgForce has set?
Yes, I don't know. There's a lot of money being invested, obviously, and that's what we did sort of find out really along the way in all the digging, is that one, I was surprised to know that the technology attracts a charitable deduction for research and development. So that was a little bit of a surprise to me, but I suppose it sort of theoretically makes sense that the investment in this sort of technology in a research and development context attracts the charitable deduction as educational, I suppose. So there's been a lot of money put in it. you know, where money's involved, as you know, it's very hard to get people out of the rut. Remember, slavery took 30 years to abolish because people said, I'm making a lot of money out of this. This is really lucrative for me. So, you know, money, I think, embeds people. I think it comes down a bit to this other idea about what they're going to be required to do in terms of abatement as part of other mining activities, and the extent to which government's a bit more innovative about not insisting upon this sort of abatement and sequestration. And I do think that is happening a little bit. I suppose, I don't know, I'm a cynic because lawyers only see cases, you know, where people sort of don't act well. So I wouldn't be surprised to see a bit more of a push to see if they, if CTSO can't sort of pull this off in some way. But at the same time, I think it's going to be a pretty hard ask, I think, for them to succeed. But the money's been invested and the arrangements are there, and it helps with their abatement plan, I guess, and at least the appearance of reduction of emissions. So maybe a bit more in terms of the precedent value. Again, you turn up with lots of people, you have success in litigation, you have success with the state government, at least in terms of persuading them. It's a really good political precedent, if nothing else, because it shows that when you really need to turn up the pressure, you're capable of doing so. So I think, in effect, you're a player that's got a bit, that instills a bit more fear than you probably did beforehand.
Thanks.
Mine is typing, so there could be another question.
Another question for me. The only other thing I would add to that question is one of the biggest mysteries to this thing from the start, which suggests there may be more coming, was on the 9th of February 22, the then government made the decision they made to waive the application through. We sought from the new Minister of the Environment, Minister Plibersek, for her to call it back in for review. That's all we asked for. And calling it back in for review is something the Minister has the power to do by the pen that sits on her desk, given the office she holds. And one of the main reasons we ended up going to court was for reasons we still don't understand. The Minister for the Environment, who was elected and whose party was elected on an environmental platform, refused to draw on a decision for review. And we didn't even ask for what the review of that decision should be. We just asked her to draw it in for review and provided the scientific information that would encourage her to do so, and indeed was made public through the state EIS process. So that tells you there's more behind this than meets the eye, which is to the question about whether we'll see this again. It tells you why one of the main reasons AgForce drove this as hard as it could, as far as it could, because there is something going on we're still not aware of. And when you read certainly the information we've uncovered, but also the information in the public arena, there has been hundreds of millions of dollars invested by both sides of government over many years in this project and other considerations around CCS. And on everything I understand, meeting our 2030 targets was actually a little bit reliant on that project itself, which proposed a modest injection for 3 years, and then assuming they couldn't see anything wrong, a significant ramp up. And they were talking hundreds of millions of tonnes going into the Great Artesian Basin at the end of the 3-year trial, enough to have made a difference to our emissions profile by 2030 and the targets that this government set. So all of that tells you, unfortunately, the game's not over, despite the best efforts of some of the best in town legally. But again, we've built a stronger foundation, I think, is the message for the next stage, whatever they might be. But fundamentally, reform of the EPBC Act, a water trigger in the MNES provisions that gives full protection to the Great Artesian Basin across Australia is the only answer, and is the part of the campaign that I think still to come. And we do have a federal election coming up between now and May next year. One of the things AgForce will be trying to do is to give every Australian the information about this as one set of information they consider when thinking about how they vote in May next year. So it will be an election with some big issues, and we hope this is one of them, given it's so fundamental to our futures. Yeah. Tony, has another one come through?
Yeah, well, there's two, actually. How much of a grudge will Glencore and the Australian government now hold against AgForce?
Well, hopefully a constructive grudge, you know, you want, it's, what if, you know, Machiavelli would like this, wouldn't he? So it's not about being loved, you know. You've got to have some element of fear, and power doesn't understand niceness, you know. So maybe if you're in grudge territory, it's sort of all right, you know.
And the next one was, are we able to highlight the government's shortfalls with this case in the public domain?
Yes, everything that happened in the case is public. There's nothing behind the scenes that happened that's not public. So the submissions were public and filed. And the facts are the facts, as long as it's kept factual. That's what it is, what happened. And the fact is the minister dug in and the minister said that AgForce didn't have standing. That's, as I said, not a right thing to do, I think, but it was done. Anyway.
And the other bit, just to that question, Tanya, is the original piece we sought from the government with legal support was a statement of reasons. And whenever a federal government makes a decision on behalf of the people, you can seek a statement of reasons, which is the statement of reasons for the decision they made. So we sought that in December 2023, and we got it in February 2024. That's our information, that's publicly available information, and that tells the story of the 3 weeks from January to February when they considered this whole issue and waved it through. And I can assure you that the amount of paperwork and the depth of consideration reflects the 3 weeks in the summer holidays feel about it. It is woefully inadequate for something that is so fundamental to Australia. And that's our information now, and we've got it, and we will use it to keep the leverage and the pressure up to make sure the Great Artesian Basin is protected. So, you know, enormous values come out of the exercise, even if it's just the information we now have we can use in public.
Well, thank you. That's it for me.
That's it for me. Oh, one to go. Sorry, Jonathan. Thank you.
Quick one. I'm sorry. Peter Dart, does the proposed changes to the EPBC Act deal with other aquifers as well as the Great Artesian Basin? Because there are other aquifers that are at risk from this process.
The one in the legislation in Queensland at the moment only deals with this particular tenement and then the Great Artesian Basin as unavailable. At the moment, that's the proposal. I'm not sure if there's anything proposed to the EPBC Act itself. So at the moment, it's just the GA.
But it should be a precedent on which the other aquifers that are at risk.
Yes.
Because the kind of pressurisation that you've talked about for the GAB is also in potential process in these other aquifers to get drainage and leakage of pollution into it.
Yes, and a recognition of the unknowability, if you like, of the interconnectivity, you know, and the porous nature and so forth. But
yes,
it's a constant thing we strike with aquifers is people really don't know what.
Yeah, well, it's a space that I've been writing in. There's a couple of papers recently that I'll send on to you, but and Mike and AgForce have it. But it's to do with the issue of, for example, subsidence is another issue which is in the same vein as pollution and so on of aquifers from the mining that's going to occur.
Yes, no, I agree. But at the moment, there's only the GAB that's been selected out as.
Yes. So how do we go about strengthening the reach of that legislation?
I guess in the same way that's occurred here, you know, that this was about the GAB and this is the legislative solution. So there might be other points in respect of other aquifers.
You know, it's part of the, as you said, the bigger story of the CCS being a nonsense anyway, but that's and then somehow marrying that with the potential to pollute. I mean, we're talking about Beetaloo.
Yes.
And we're talking about Fitzroy Crossing at the moment, for example.
Yes.
So it's a very big issue that is sitting in the background, unacknowledged.
Yes, I mean, Beetaloo, for example, because it's deep fracking.
Yes.
I've done a bit of work up there. You know, 2 kilometres down, they say, well, even if something went wrong, it could never possibly affect human health. You know, is the concept.
Yes, indeed.
But of course, that's a pretty, fraught concept itself, isn't it?
Yes. Well, again, I put a submission into that inquiry.
Yes.
And as to the Senate inquiry, I also put a submission in.
Yes.
But these are issues which are sitting unacknowledged by government because they use what is now called the Queensland Gas Commission.
Coexistence Queensland.
Coexistence Queensland, because they use that as a cover for the lack of real scientific rigor in how they handle this space.
Right.
So
We'll see. For the other fights, but
thank you.
not going to end, are they?
Can I ask you one question in closing?
Yes.
And thank you for your generosity of time and spirit this morning. And then there's a couple in the room I know want to speak as well. But just to say, Jonathan, we've achieved so much. We've built a foundation, which is really important for the next piece. I guess the one bit we didn't get was the judicial review of the decision. Can you just quickly in legal terms explain why what we set out to do wasn't fully achieved?
Yeah, two things. When the delegate had given the reasons for having decided 2 years ago, he misstated a test, which was, is this a large coal mining project? Whereas the test was, does this involve a large coal mining project? So he directed his mind, it seems, to the wrong test. He applied a higher threshold than he needed to in deciding its connection, because that's one of the threshold tests. Is this connected to a large mining project? We said yes, because we connected to the Millmerran Power Project. And the court's already said one adopts a fairly wide interpretation of that. So that's the test that never got determined. But the court's already marching towards a wider test of that, i.e. a test that's more favourable, saying things are involved with large coal mining project, even though they're not directly associated or next door. But here we've done a lot of work to show it was involved with the Millmerran Power Project. And the Millmerran Power Project is, of course, with the Commodore mine next door. So to show the interconnection, in effect, not only proximity physical, but also through conveyors and so forth, and common ownership, similarly. And the second one was, is it likely to cause significant impact to a water resource? And that was the other point we wanted to run, a subsidiary point, but which hasn't been tested. That is, what sort of evidence do you need before you have to, you can be satisfied that it might cause, significant impact? So those two questions aren't going to be determined, but they're the questions which we sought to raise, and both of which we said were approached in error below. One, because the wrong test was applied, the delegate just states the wrong test, which is a bit of a no-brainer in terms of an error. But then the second one was there was material readily available to show the impact, major impact on a significant impact on a water resource, but it just seems like that was glossed over because CTS got its material and said, well, you never need to decide that because it's not connected to a large coal mining project. So the thing just never got properly considered. And that was the overall approach of the case, I guess, to say the merits of this case were never properly considered by the delegate. It was a rush job, and the material that could readily have been accessed and available to fully inform the person were never put before them, and they didn't go searching for it.
Thank you, Jonathan, very much for everything.
Yes. Thanks.
I'm just conscious. Bill, did you want to say something, or did anyone else?
Yeah.
Bill, please. The floor is yours. Grab a seat.
Would take much more than 5.
No, that's right, Bill.
Bill Bode from Prairie, 4 hours west of Hughenden. What I want to talk about is the history my family has had with the Great Artesian Basin. My grandfather started about 1890. My father started about 1926, and I started in 1959. I had three brothers and myself and my father all had Class 3 driller's license for cable tool drilling up until 1965. I've still got mine. I think the rest of my brothers have put theirs in. But what I'm really saying is we know the Great Artesian Basin, especially up our area. We've got the clematis strata up there, which is exactly the same as the precipice strata down southwest Queensland there. And it's pretty deep. Not many people access it. I know of 2 bores in my area that do access it because they have to go down it to get enough pressure to get the water flow. I have been a member of Ag Force. I was one of the original board members of Ag Force, the General Board as well as Cattle Board. I was a member of Cattlemen's Union for 81, right through till Ag Force was formed. I was on the Great Artesian Basin Advisory Committee for 19 years. The reason I was put off because government in their wisdom said there had to be an equal number of women as well as men. I was one of the original ones. 1988, I think, Great Artesian Basin Advisory Committee was fitted. I was, up until I was sacked, I was the last of the originals put on it. I don't know if any of you people here know, but Pat Casey, a Labor minister, was the original person who got the GAB advisory committee going, and I applaud him or his family for the work he did for the GAB, because in the time we've had it, we've saved 235,000 megalitres of water each year, and there's up to 15 to 20 metres of pressure recovery, which, as far as I'm concerned, is more important than the number of megalitres saved. But only for about less than $400 million of taxpayers and producers' money. That's one fantastic result. It's the best result any government department has ever done for Queensland. But don't forget, the GAB covers 70% of undergrows 70% of Queensland and 20% of Australia. And a lot of people don't realise that. We still got around about 100 bores that haven't been capped, because as we're capping the bores, more bores start flowing again because the pressure's rising, which is, I'm not worried about the amount of litres. I worry about the pressure, how much pressure we've got to keep the bores going. Other than that, I came from, as I said, 4 hours west of Townville. I donated $1,000 for the Ag Force Fighting Fund. And I'm pretty sure if we have trouble, we just have to ask the people of Queensland. They'll give us more money to fight for the effect.
Thank you, Bill. That brings us to the end of formalities. So thank you for those joined online. Thank you for those that have contributed so much to this campaign over the last 8 months. The generosity of Queenslanders, just to touch on Bill's comments, has been amazing to me. I have seen people donate incredibly generously where I can imagine they've got many financial challenges. I've seen people donate their time incredibly generously when there are other things that are important to them. I've just seen the Ag Force family come together at this important time with that generosity collectively, making an enormous difference to the outcomes of this. So I just want to thank everybody in the room, online and across Queensland on behalf of membership industry for everything everybody's done. It's been a huge win, and it's in no small part due to the generosity of all of those who've contributed. And while the campaign's not over, it's been a significant win, and it provides a really powerful foundation for the next piece. So thank you. And for those in the room, there's a bit of lunch coming shortly. Please stay if you wish to. Please use the coffee machine. For those online, I hope this has been helpful. So thank you to everybody.